Well, hello again. I was
Hello
just live a
yourself.
minute ago. We are live now, right? Are we live?
It says we're live. What's up,
Okay.
everybody? Happy Friday evening.
Yeah, Friday the well, it's not Friday evening anymore.
Friday the 13th. Well, not for
Saturday the
you.
14th. Well, it's still 13th to you, right?
It is the 13th for me for a few more hours, and I just put the girls to bed, and we just got done watching the first third of Ace Ventura, Pet Detective.
Oh, yeah.
We put them to bed after they did the talking butt scene. So, we're doing great.
Well, that's the best scene to end on.
I mean, I don't know. I had to introduce them to Ace Ventura somehow. And I haven't seen that movie in a while. It's not as PG as I thought it was going to be, but you know.
Oh, really? Yeah, it's funny. It's funny when you watch something yourself and you don't realize, and then you watch it later and there's kids around and you're like, uh-oh.
It's like, I didn't remember that when I was 12.
Yeah, I didn't know what that meant, right?
They had a full-on oral copulation scene that I forgot all about all of these years.
Well, that's
my wife, and she looked at me and was like, yeah, it was the 90s. It was a different time. It was a much different time.
I don't remember that either.
Oh, it's in there, and my girls saw it on full display, so.
Oh, great.
It was one of those 90s exaggerated cartoonish scenes, you know.
Yeah. Yep.
You know the kind.
I know the kind.
Anyway.
Before we get started, there was a leftover question, and I think there were two. And for those of you in the chat who remember, I think there were two questions that were put forth for me to ask you. The one that I wrote down was apparently someone spoke about wondering if, I don't know what the story is because I didn't hear it for myself, but I just saw the comment, wondering whether or not it's possible that Blake's attorneys are doing this case on contingency. I say no way.
No effing chance. There's no way.
Right?
And if they are, they're idiots. There's just no way.
That's exactly what I said, but a little bit nicer. No, I said stupid. That's not better. So
I'll tell you what. I take cases on contingency sometimes when I know I'm going to win. It makes no sense for me to put my firm, commit my firm to a major civil complaint that's going to eat up months and months of our time and take them hundreds of hours of billable hours. And we have to win the case. Well, there's firms that do that. My firm does that. But we only do that when there's greater than an 80% chance of getting a favorable outcome, or at least recovering somewhere close to the hours that we billed. So this case has been shaky from the jump. Thanks, babe. I got my rum and Coke in hand.
Nice.
Yeah, I mean, every firm has different standards for how they're going to take contingency cases. But my standard is I have to know beyond a reasonable certainty. To me, that's about 80 to 85% that I'm going to recover. There's no chance unless something goes really wrong or my client's a 100% complete liar. The case has to look so good. And so you'd have to imagine that I do my due diligence. And then I'm looking into the veracity of the claims. I do some background checks on the folks. I make sure that there's an asset that they're fighting over where the law says that they're, at the very least, they're going to end up splitting it. But in a sexual assault case, on those claims, there's no effing chance that they took this on a contingency.
Yeah, absolutely. And don't you tend to do it for clients who may not have money to pay everything in advance?
I'll do it I'll do it on Marvin cases. For example, I'll have a case where you have a couple, they've never been married, but they got 3 children. And they've been together for 18 years. And they bought a house together. They've been living in for 12 years. But they never married. They just never did. You know, there's not a such thing as common law marriage. But there's this case in 1976. It was a Lee Marvin case. And he was living with a young lady. And she basically tried to get him for palimony. Basically, he owes me support because he promised he was going to take care of me. Now he's breaking up with me and leaving me with nothing. And then the court's like, yeah, we're not going to award it to you. But I'll tell you what, in the situations where we would award that, it's in the case where you have 2 people that they've lived their lives together. They've pooled their assets together. They're raising children together. but for, the formality of marriage, they have lived their lives and existed in a world where the universe thinks that they're married.
Right.
If they didn't know about the marriage certificate, then, whatever. And so in a court of equity, we can divide their assets as if they were married, such as applying California's community property rules. That's a very easy case to win in that factual pattern, right? And so I'll take those cases, and oftentimes the person that is looking for palimony has no money. But I know at the very least, I'm going to get the house divided, or I'm going to get the retirement accounts divided. There's no way we're going to not recover based on the facts. And so I'll take it on that case. Or like you'll take it like you see a lot of PI attorneys do it, where their client is not at fault and there was injuries and medical stuff. But in a case as ambiguous as Lively's claims against Justin, for the claims of being what they were, I just cannot see any attorney saying, oh yeah, definitely, we're going to win this one. We're definitely going on a contingency. No, we're going to bill her at $1,000 an hour, which is our normal rates. You may or may not win. And if you really want to take this, you might not have the strongest case. I can't promise you that you're going to win. But I will put forth our very best efforts. You're just going to have to pay a regular retainer. That's it. And maybe they could work out a deal where it's partial retainer, partial contingency. I don't know. But no, there's just no chance this is 100% a contingency. I apologize for my ranting long answer.
No, my answer was long and ranty too. I just do not see it. Absolutely, it would be the stupidest thing for them to do. And yeah, to me, it's not the situation or the firms or any of that would call for a contingency. It's just Jordan, a little off topic for my non-Murdock people, but do I think Buster will win? I think he might win against the local DeWitt, because the way DeWitt worded some of the stuff was I don't know. Yeah, it just sounded not neutral enough for me. As far as like the documentaries, I don't think so, because they just had people on there talking. So I'll have to get into that one later when I'm doing a Murdock thing. But since this one is not a Murdock, that's about all I'm going to say about it on here now.
So funny that you hit me up today, because just the other day I was talking about you. Like, hey, Cassidy, we were supposed to be doing a whole Murdock thing. We're like missing episodes 7 and 8.
Yeah.
And like, oh, I thought you guys were done with that. And like, no, we weren't. We were supposed to like finish.
More. Yeah, we
did the appeal. We're still. I still haven't watched episodes 7 and 8, by the way. So.
Oh really? Oh my goodness. Oh yeah, you're in for a treat then.
I just got busy doing other stuff, man. It's been a crazy month or two. I don't know. Yeah. You got real busy. I got real busy.
Yeah, I spent the majority of the last 2 months. I was in Germany more than I was home. So.
I remember, and it's funny. I'm about to take off. We're taking our family trip down to Mexico.
Oh, nice. Oh, yeah. I remember you had that coming up.
Yeah, that's coming up. We're leaving on Thursday. And so.
Nice. Oh, enjoy.
Well, we'll try. Once we had like people in comments saying that, we don't care where you're going on vacation. Just get to the things. Like, well, you know what? It's Friday. So how about I'm just going to talk about what I want to talk about. What do you think of that?
How about that, right?
How about that? Exactly.
Okay, sorry. Can you take it for a second?
Do you want? Yeah, I got you. Okay, so look, I will give you guys the introduction to this case. This is why it's interesting. Number one, does it bear implications to the MSJ? I think is the biggest thing. There was a sanctions motion. Friedman denied it, and then Cassidy had this brilliant idea to tie a case that he has litigated. I don't know, like a decade ago or something. But it was the exact same kind of a thing. And it demonstrates that Judge Liman has a really big heart-on for a causal connection. And if you recall in the MSJ, and why this is relevant to like what we're due for, because he hasn't made a decision yet on the MSJ, but he was really, during the MSJ deliberations, I say deliberations, really what they were was the attorney arguments, he was not impressed with Lively's presentation of the facts. How was it a smear campaign if this stuff happened like 9-12 months apart? So this thing happens 9 months ago, and then 12 months later, they're initiating a smear campaign. Where is the causal connection? He's really steadfast about that. Part of the reason why Liman has denied this latest sanction request from Blake Lively was because of this temporal element, that the statements were made too far in advance to necessarily be prejudicial to you. Therefore, I'm denying sanctions about that. And that's it. That's like the entire sanctions argument. In a nutshell, that's what we're looking at. And so why that matters and why that's such a big deal is because it gives you some insight into what Judge Liman is considering, or the way that he's thinking and the way that he's historically thought about these things. It's really important to him. And look, I just had a conversation about one of my clients this morning. The judge is important, and you have to understand the way that they think. Like, there's some judges, you're going to give them hundreds of pages of evidence, and they're going to read through all of it, and they're going to know stuff, and they're going to ask you questions like they're appellate judges. And those are great, because then you could just reply that you're going to file stuff and get them in front of the judge, and they're going to know what you're talking about. There's other judges that don't like that at all. And if you don't summarize it for them succinctly within a paragraph or two, and realize and make them realize that your arguments and the thing that you're asking for that is otherwise unconventional is based on evidence that has been attached in the pleadings that has otherwise been admitted in evidence, then he's not going to rule in your favor, because he's not going to work that hard for you. So you gotta put it to him like he's five. And for Judge Liman, he has identified, and Cassidy has gone through the trouble and has brilliantly connected the dots, that Liman is really big on these causal connections. If you're going to argue that you've been prejudiced by statements, then I need to know that there was some direct bad thing that happened that was necessarily consequential or a consequence of the statement. In this case, I think it was like 9 months or something like that. 9 months had passed. So where's the prejudice?
Yeah.
Based off of that, nobody's been prejudiced. I'm not sanctioning anybody. But that's important, because during the arguments with the MSJ, he was asking them, how is there a smear campaign if this happened like a year ago or 2 years ago? And now you're saying now he's smearing your name during the advertisement period for the film as it's coming out. That doesn't make any sense to me. I don't see the causal connection. If he doesn't see the causal connection, historically, Judge Liman has ruled against you. And Blake Lively's, the issues with the MSJ are necessarily, the timing is really important. And Judge Liman, he laid that out over and over and over again. He asked their lawyers over and over and over again, where is the causal connection? And that's kind of what today's show is going to be about. And Cassidy's put together a brilliant slideshow presentation, and I'm going to let her lead the charge on that. And I'm just here to provide color commentary. How about that?
Okay. I am so sorry to hear that, Redondo Beach. Last year, I had surgery because I tore my meniscus as well. I didn't have a double. I had that, but I also knocked out some cartilage. So I had to, and I have lupus, which creates around connective tissue. It had grown too much in there, so they had to cut that out, repair the meniscus, and drill into my femur to try to replace the cartilage that I lost. It was one of the most painful things I ever went through. And the only good news I have for you is that after the surgery, it does take a much longer time to heal than I expected. But I am like, I mean, I just walked literally miles through Germany on this like romantic road hike thing you can do. And yeah. And I mean, it's
romantic hike. I did that once with my wife.
The romantic road?
When she was like 5 months pregnant. We didn't get very far. But I couldn't believe it on her, because she was like, it's like we were in Hawaii. It was like our honeymoon. And like we couldn't do anything because everything, like we were going to go on a dinner cruise and like, oh, you're 5 months pregnant? Sorry, we can't let you on. We can't go on the boat? No, you can't go on the boat. It's like, well, shit. So we were trying to find things to do. It's like, why don't we go on this like hike down this mountain with a waterfall? All right, cool. And then we made it as far as, look, I don't know what it's like to be 5 months pregnant. I do, however, know what it's like to get a vasectomy. So I'm not saying those are the same things. All I'm saying is I look at my wife a whole different way, trying to traverse down that mountain at 5 months pregnant. I gave her shit about it back in the day, but I would never do that now.
Aww.
I was also going to say something. The lupus thing. Did you ever watch that show, Dr. House?
Yes.
Like the running joke being, it's never
It's not lupus. Yeah. Yeah. Yep.
except
Thank
in your
you.
case, it actually is. So,
Yeah, unfortunately, Judge Liman made a smoking signal. So this, you know what I love? My favorite thing about this to me is that they did those long, like you said, they didn't make it concise. They didn't do the work for him. They had that long thing for sanctions and they kept adding to
yeah,
it. He didn't even consider it. He's like, look, it's nowhere near the trial date. So even if the statements weren't protected, it wouldn't matter because they're
yeah,
just not in the right time frame to cause any prejudice. So he's like,
right.
I'm not even looking up all these laws. I'm not even looking up this procedure. I'm not even going to consider whether or not he was
It's
covered
risky, but
because
he was
it's
that
just not
confident.
yeah, and
Yeah,
it's just not the right time. It's like the smallest order. It's exactly what they deserve, and I love it. And because, like you said, to me, it's a signal that means so much. Because, like you mentioned in the hearing, that was a big thing he wanted to know. It's a
yeah,
big part of the MSG, just like you said, or MSJ, not G, and
yeah.
MSG is that spice that makes everybody swell. But
MSG makes food taste delicious. Where's Uncle Roger? Uncle,
But, so he mentions the FRCP 16, that's just that people can do sanctions, and then this is the New York rule, and I did a video about this that explained it in a lot more detail, so I'm not gonna go into, much detail on it now, but it basically it talks about when it's okay for a lawyer to make these kind of statements, what kind of statements are okay, and everything that they accused Brian Friedman of doing and saying, it all fell under part 4 and D.
yeah,
So it was things you can say like after the other side has made a statement, and I literally went through the things they accused Brian of saying, and I looked in like the day before or 2 days before whether or not Team Lively had made a statement, and they always had. I did a whole video showing it was in response to something Lively said. The
sure.
other the other option is you can do it after there's been some significant point done in your case. And so in all of those cases, it was always Blake had spoken first. And some of those times was after something significant in the case. Like, for example, when he granted the motion to dismiss that Wayfair had against all the other parties. So he was
Right.
well within these standards in the first place. But the judge was like, I'm not even going to look at that. The timing's way off and
Yeah.
forget about it. And that's like that's all the answer he felt they deserved, and that impressed me so much.
That should, I mean, even further, just the brevity of that decision should further impress upon everybody that's curious about how he's thinking about the MSJ.
Yeah.
He really is big on timelines. And if the timeline doesn't make sense, he's not going to rule on your favor. You're not going to get one over on him. That's his big thing.
Yeah.
That's his big thing. And so,
That's
look, I'll give an example of where you could have prejudiced somebody. Like if if Friedman would have came out and started talking about, say, the judge being unfair or the Second Circuit being unfair to litigate this case, or somehow like raising doubts into the fairness of the trial, that would be one thing. It's against the rules of professional conduct.
Mhm.
It would be the kind of thing you get sanctioned for in a civil case like this per the federal rules. But sharing your opinions based on publicly known information or information that was allowed to be disclosed by your clients in a case that's going to be litigated where there's genuine factual disputes, that doesn't really fit the bar. I mean, you hear attorneys give their opinions about their clients all the time, and they always say something like, look, I look forward to proving my client's innocence, or I look forward to proving the ridiculousness of these claims against my client. It's always something to that effect. In the case of Brian Friedman, he released a whole website. Is that out of line? No, not really. I mean, if all of those things are factual and they are generally known to the public, and there wasn't anything in that website that wasn't documented somewhere in the general
Public
stratosphere.
filings.
Yeah. Oh, thanks, Winks. I appreciate you. Yeah, it was stuff that's already made public. He was speaking about stuff that was already known. He wasn't making false statements or false characterizations about folks. He was defending his client, which any client that is in a public case has the ability to do. Live didn't like it because it made her look really bad.
Right.
But the facts make her look really bad. You don't have to read that website to know that she's got a weak case. And so the fact that Judge Liman didn't even have to get that deep into actually analyzing the statements themselves, he dismissed it on a temporal claim. They're too far apart to matter to me, or for you to make any sense to me that these were prejudicial to the trial. I'm not going to consider it. We're done here. We're finished.
That was it. That was it. I mean, I actually laughed because I was expecting when he gives an order, when he makes a decision on something like this, it's normally like so long.
Yeah.
And that's what I was expecting. And it was just like, nope, I'm not even going to talk about the legalities of this. It's not, the time's wrong. That's it. That's all you get.
Right.
I thought it was beautiful. But
if
yeah.
if you extend it out, Lively is basically trying to conjure up. And the biggest weakness of her case is that she never filed a formal complaint, right? She's tried to clean that up by saying, well, we complained to Sony, just not formally. We complained informally. Well, nobody gives a shit about your informal complaints.
Exactly.
The reason why we have formal complaints is because there's a paper trail.
Right.
Paper trails are really important when it comes to lawyers because
sorry.
No, they just create benchmarks where, okay, this happened, so how did you respond? If you're going to say, well, I tried to make a complaint, but I didn't actually make a complaint, I can't do anything with that because it doesn't compel reaction from the other party. So you want to say you complained to Sony, made this informal complaint, they said you're barking up the wrong tree, you go bark somewhere else, and you didn't go bark. What are they supposed to do then? What are we doing here? It's previewing this. It's previewing that I'm fully expecting, based off of this ruling and based off of how Liman reacted to Lively's arguments when they were arguing the MSJ, I'm fully expecting the sexual harassment elements to be dismissed.
Yeah.
100%.
Yeah. Yeah. And I'm right there with you. I agree. So what this table is, this was actually a thing of beauty. This is from the Bravo case. So I had talked about this case pretty extensively as far as the harassment claims and how they hadn't survived, but it was some time ago. And this case just popped back up into the community again because some things had passed and Andy Cohen, I believe, had moved to try to have it done in mediation, like away from the public.
Arbitration.
And Liman said, no way, Jose. And so it kind of brought things back, but it brought me back to this chart. And I went back and looked at where I'd only looked at the sexual harassment claims before or discrimination claims before. This time I wanted to look at the other stuff. And he really impressed me with this chart, I have to say, or whoever his clerks were at the time that made this from last year. And this case, this is a current case. And this motion, I think, was last summer, like sometime in the summer, that he decided this is the motion to dismiss. And this woman brought like 33 causes of action. And there was no good way to do it besides making this table. So I think it's really, really helpful to look at. And the case is McSweeney versus Cohen. It's a Real Housewives case. I've never watched the show. I know who Andy Cohen. Yeah, I know who Andy Cohen is.
One of the Housewives, coincidentally, but I've never watched the show.
Yeah, it's not my jam, but I know it's a really, really popular one. So, but it has some of the same claims, and I think it gives us, because this is a Judge Liman case, it gives us really good insight into what he considers when he makes these kinds of decisions. So it's different because this one is New York law instead of California law. But I wanted to ask you, as we go through it, to maybe give some comparisons of what you might know about California compared to what the decisions are here under New York state law.
Sure.
I also have a struggle thinking Blake is going to be able to apply California law because she's a New York resident and this stuff happened in New Jersey. So on what basis can she even do that? But if by some chance he allows it, like,
Yeah.
there's some things to note here. But where it says 42 USC, I want you guys to notice that is Title VII.
Yes.
So he wrote it down as the actual section of the law, but when you see that, just tell your mind in your mind, say Title VII, so that you realize it's the same as what Blake is up against. So that's an important thing. But the green ones are the only ones of the whole 33 that survived. Everything else was dismissed. If I highlighted it in yellow, it was dismissed without prejudice, which means they can try to cure those and bring them back again. The ones that were just, say, dismissed, and I didn't highlight them at all, those are dismissed with prejudice, which means that's it. Can't do anything about it. Those are done.
Done. That's been decided. You can't bring it again.
Done and dusted. Okay, so
Done and dusted.
I love that British saying. So the first one that survived was this disability claim.
Yeah.
But, and this isn't a Blake claim, but since this one survived, I wanted to go through and just show like how these kinds of things survived, like what made them survive when almost nothing else did. Because of the fact that the defendants in this case knew that she had disabilities. They knew when they hired her. She fully disclosed it. She directly told them about it, and they experienced it during filming.
And if you're unfamiliar, like the claim was she had an issue with alcoholism. And the claim was the producers and everybody filming was trying to encourage her to drink more to get that stuff on camera.
Yes, because it makes better TV.
Yeah, the problem with that was that's an ADA disability covered claim. And she was arguing ADA disability discrimination. And that happens to be covered under the ADA. And in California, they don't F around with the ADA. Like they're really big on if you got a disability, you can't discriminate against folks like that or take advantage of folks like that based on their disability. In her claim, whatever they thought about the merits, was that she was being compelled to drink on camera when they knew full well that she had this issue with alcoholism. And that's why that survived in the McSweeney case.
Mm-hmm.
However, the Title VII stuff did not. And the Title VII stuff matters because Lively does not have an ADA claim.
No.
She has a Title VII claim, kind of, sort of, which she kind of led on during the MSJ arguments that they only kind of brought a Title VII claim because they knew they could get more money doing that. And the judge's like, okay, why are we bringing Title VII? And they said, well, because we could get more damages. All right, gotcha.
I want to see what note he wrote when they said that.
Yeah. Anyway, the Title VII claim did not survive in McSweeney. The ADA claim did survive, but they had to. The ADA claim had to survive. It's just a much lower threshold.
Right.
Title VII it's not that it's a low threshold. It's just it's a higher bar.
Right.
In McSweeney, there was a formal HR complaint. In Lively's case, there was no formal HR complaint, but she says that she kind of sort of told Sony there was an issue and they told her to file a formal HR complaint and she didn't bother. Right. In McSweeney, there was a contract, non-renewal clause. There was a concrete adverse action. There was real stuff. There was actual real contracts that were signed. In Lively's case, it's not clear what the contracts were because there was no contracts that were signed. What are we doing?
Exactly.
In McSweeney, there was a causal link. There was Cohen's text that documented this causal link between the ADA accommodations and their discriminatory practices. There doesn't appear to be any causal link in the Lively case. There's no text equivalent. Yeah, it's all speculative. Like we're throwing it out in the ether. We're throwing it at the wall and we're looking for something to latch onto. And there's nothing. There's no temporal causal link. There's no direct causal link. There's not a rational causal link. And so therefore, MSJ, right?
Right.
In McSweeney, they had the ADA standard that they were going by. That's much, much lower than any Title VII claim. There's not an ADA claim with Lively's case. It was only Title VII, sexual harassment stuff, breach of contract stuff, smear campaign stuff. That is a much higher standard than ADA. McSweeney had corporate defendants. Most of the individuals were out. It was really a lawsuit that ended up being about corporations, not the individual parties involved. In the Lively case, it needs a corporate element. There's individual defendants. They're trying to insert individual defendants to bolster their damaged claims. They're suing corporations, but they're also suing Baldoni individually. All I'm saying is there's a reason why McSweeney sort of worked. And the only reason it worked in essence is because there was an ADA complaint where there was a causal link to a violation. Lively has nowhere close to a causal link to anything. And the standard for her is much higher because there is no ADA claim. It's all sexual harassment stuff. And not to repeat myself, but if you're reading the tea leaves and the smoke signals that somebody in the chat had suggested, this is a preview for how Liman is thinking. Not how he's just thinking for this case, but how he's been thinking for at least a decade. This isn't making sense on a timeline for Judge Liman. He's going to whittle this down with the MSJ. I'm telling you right now, just like I said a couple of months ago, or whenever they argue the MSJ stuff, the only thing that is going to survive is going to be the breach of contract stuff. And that's not going to be worth enough for either party to go to trial on this. This is going to get settled. It's going to get settled. I'm telling you right now, there's not going to be trial on it. And if there is a trial on it, obviously we're going to cover it. I'm just predicting that there will not be. It's just not going to be worth it for either side to do this.
Yeah. Yeah. Other than, because for Wayfair, he just wants to prove he did not do this. So, and I mean, a lot of that's already happened with the great unsealing. But you said something really important here about the ADA, that it's lower bar. And part of that is this first sentence, that the ADA has requirements that employers must follow. And one of those is that they have to make reasonable accommodations to the known physical or mental limitations of an otherwise qualified individual with a disability. So they hired this woman that they knew had what is considered under the ADA as a disability. Not only did she have problems with alcohol, which she had been sober for something like 8 or 9 years, but she also, I don't know if you caught that here, she also suffered from depression, which is, I don't think that's considered a disability, but she had anxiety and she had bipolar disorder.
Right.
So when you, and they were fully aware, and knowing this, they were required, in hiring someone with that situation, they were supposed to make reasonable accommodations for her. They did not. Like Omar said, they had situations with alcohol everywhere. Well, you take someone, we're not just talking about someone with alcohol issues, but someone with the other issues on top of that, and you put everybody around them is drinking alcohol. They're in places just flowing with free alcohol just being supplied. It's just awful. But it's more than just they had that situation. So we're going to get to that in just a second, but so these are the things that are required under the ADA that they have to provide, and then we're going to get to in a little bit what they did, because that's another step. But in the meantime, the next one that survived was a retaliation. But if you look next to retaliation, I kind of blocked it with this little red thing. It says retaliation ADA, because if you look through this long list, there's a bunch of like numbers 30 to 32 are also retaliation, but they're under New York state law. There is let's see, 19 and 20. There is 17 is Title VII. The others are all New York state laws. So they do not have the same level as the ADA, and so only the ADA of these survived that as well. And why did it survive that? But first, this one, let me see. What have I got here? I always forget to look at my notes. I take the trouble of printing them out. So if you've been watching my series about the motion for summary judgment, so Omar, you probably haven't seen, I've been deep diving that motion where I go through all of the case law that they cite and what happened in each of those cases to compare those with Blake's claims. And I mean, we've got some huge stuff. We have actual touching of a woman's breast. We have comments being made specifically about bust size. We have people talking about their personal sex lives with their partners. That was in the Friends lawsuit in the writer's room. And so just comparing, like, and none of those made it. None of those survived. So how ridiculous to think that Blake's little things survived. There were other situations where they ruled you can't talk about what happened to somebody else, like Blake's claims about Jenny Slate or Isabella. Those don't matter. You didn't witness them. So how did they affect you? And if we're told about it later, like she was, how are you going to claim harm or damages off of what somebody else said? And then there's the fact that Isabella told Justin he made it a very comfortable and safe filming experience for her. And Jenny made the statement that she didn't join the lawsuit because she felt like it wasn't that big of a deal and hers was resolved. So, her claims just start falling apart when you start comparing it to all of these other cases. But another thing that we went through that gets repeated and repeated and repeated when you go through those cases is what the standard is set forth by the U.S. Supreme Court and cases that they have seen and made decisions on. So they make very clear standards of what has to be met in order to prove that you had a discrimination or a retaliation claim. And so this one, those of my folks who have watched that, you're going to recognize this Burlington one because it gets mentioned a lot. But what was my point with this?
Well, it says it right there.
Causal connection. Yeah, that was it. Go ahead.
An adverse employment action is any action that could well dissuade a reasonable worker from making or supporting a charge of discrimination. And right there, that implies a causal connection. And an adverse employment action, any action that could dissuade a reasonable worker from making or supporting a charge of discrimination. And then it goes on to talk about, as you've highlighted, the plaintiff must still adequately plead a causal connection. Mm-hmm. You can't just say it is because you think. There has to be some kind of nexus there, some causal connection between her protected activity and the adverse employment action. The plaintiff must show that he engaged in a protected activity, that he still. Do you want me to look at the comments? Sorry. Oh yeah, that he suffered an adverse employment action, and that a causal connection exists between the protected activity and the adverse employment action. And look, Judge Liman has a hard-on for causal connections. He's really big on that. And you have to make, with this particular judge,
these are his words right here that you just read. These are his words.
Yes. If you cannot bridge the gap between the thing that you said he did and the reason that they did it, he's not going to rule in your favor. It's not going to make sense to him. And so that's your judge. And Friedman, have you seen the way for his attorneys have done? They started quoting his own cases.
Yes.
To remind him, which was a brilliant move.
It was.
That's the move. I don't think that Liman is necessarily, like, people may have these conspiracies. Oh, he's a paid off judge or whatever. He's biased towards life. He's not. He just has a specific temperament. And for him, causal connection is everything. And with Lively, the biggest weakness in her case is all these things that were supposedly happening, yet she never filed a formal HR complaint. Mm-hmm. There was this smear campaign that was happening, but why were they trying to smear you? Oh, because of stuff that happened like 2 years ago. How does that make sense? Dipshit. We're like literally at the finish line, and we're trying to advertise the movie to make as much money as we can. Now is the time for the smear campaign. Make that make sense for me. And as you
Yeah.
guys have been so apt to point out, he's got a brother that's in the Hollywood industry. That means that he understands the business. When it is time to advertise the movie, when it's a done product and we're going on all these advertising campaigns and making these public appearances to promote the movie, now is not the time for smear campaigns if we're trying to make the most money possible. So tell me then, explain it to me like I'm 5. Why is he smearing you? And for what reason is he doing it? Well, because back in 2023, he walked into my trailer and looked at my breast. That doesn't make any
file an
sense.
HR complaint.
You should have filed an HR complaint. Then I could do something about it. I can't do anything about it now. What do you want me to do about it now? All I'm saying is this is getting MSJ'd. 100% it is.
Yeah. Oh, I agree. Absolutely agree. Okay. Now, the this is you mentioned this earlier. This is why she was able to win this ADA. Now, she still failed the Title VII. She still failed the New York. But this is why she won the or didn't win yet. This case is not won. It just passed it wasn't dismissed by the motion to dismiss. So it's still alive. That doesn't mean it will not be disposed of at summary judgment or in a trial. It has survived the motion to dismiss, and that's it. But this is why. Because she issued a formal complaint to HR.
Yeah.
And there's Andy Cohen texted her regarding that complaint. So it is acknowledged right here is how she overcame the causal connection in this one, because he actually texted her and referenced the complaint that she made, and she had been being promised that she was going to be re-signed for the next season or put in another show that they were going to do. And then he mentions, she filed this complaint. He tells her she filed this complaint in a text message that wasn't very smart, Andy Cohen. And so there was the causal connection of why, after all the promises, she did not get recast for the next season or for the other show. So
it's funny, man. I'll tell you what.
You have to have a legit complaint and a causal connection.
I litigate these cases all the time. And 80% of the time, I would estimate, I'm arguing stuff based on he said, she said.
Mm-hmm.
And those are so hard to litigate, because then it all comes down to credibility. And how do you judge credibility when the judge only sees you for a couple of times, a couple of hearings or whatever, and they're supposed to make decisions based on your credibility within a couple of hours that you're in the courtroom. These celebrities, they are in the public consciousness for much longer. Lively's made a lot of statements, and if it comes down to credibility for he said, she said, Lively's going to lose. A lot of what she said just doesn't make sense. Not to a man, not to a judge. You're not giving him a causal connection. You're not making sense to him. How is he supposed to find you credible? The thing about making formal complaints is it compels the other side to take action. And it doesn't allow for this he said, she said. Here's a formal complaint. What did you do about it? Nothing? Then you lose. Something? All right, well, then let's see what the merits of the facts are. And Lively's biggest complaint is that she's been trying to litigate this case, I feel like, since the inception of it, like based on this, she's been trying to paint herself as this victim that should just be believed, trying to like latch on to like 2016 Harvey Weinstein, believe the victim vibes, right? When the country has moved on from that. We're in a much different place than 2016, 2014. We still hate Harvey Weinstein, but I think that that America as a whole is more sophisticated when it comes to these claims, because we've seen both sides of the extremes when it comes to, believing the abuser and believing the victim, and you can't believe either. It's somewhere in the middle. And so we're more skeptical of her claims. If she had just filed the formal complaint the way that she should have, instead of trying to convince the judge and the general public, well, Isabella is going to like vouch for me, or all these other actresses are going to vouch for me. And all my friends think that Justin's so weird because how dare he laugh at the jokes that we were making about a bed being too small for sex or whatever it was that we're talking about during the, whenever When did that even come out? Like there was literally like a situation where she was like joking with her friends and they were talking about a bed being too small for sex. And then Justin's like, yeah.
Jenny. That's why Jenny didn't like her apartment. She said it wasn't good for sex.
And then, and then Justin laughed at it and they're like, how dare you laugh? Who said you could laugh? It's like, well, I'm sorry. I thought we were all like laughing here. It's like, no, get out of here. It was like this weird,
it was so dumb.
It was so weird. And I mean, dumb, weird, however you want to categorize it. It was just, you cannot.
How it turned out is Jenny used the reason she needed a different apartment was for her sex life. That's what she tells her bosses. And then the situation was
Blake, boss, by the way, Jesus.
Yeah, Blake had told Justin that her whole family sleeps together in the bed. And so why are these women
sleeps in the bed?
Blake told Justin that her kids all sleep in the bed with her and Ryan.
Okay.
They have
I won't let my kids sleep in the bed. No, they're not potty trained sufficiently. I will not. I will not, man.
So, but I'm like, okay, how are you literally suing Justin in federal court for during a scene where you're supposed to be plotting out how a sex scene is going to go in your movie? It's a creative situation. And he mentioned something about him and his wife. Okay, under those circumstances, but yet you and Jenny have both in a situation that was not professional, was not a creative writing situation. You have both disclosed something about your marital beds. Like, what in the world? You can't sue him for something that you yourselves have done. It's crazy.
You know, man, I can't reiterate the cases that I have in real life and like the stuff that I see some of these women going through and like the genuine, like real stuff, like real life situations, like people that are like literally being sexually assaulted in their own homes. Because like their husbands want to be like a physically domineering or like they're jealous or whatever. And so they're like violently going about things and they're like living in this personal hell. And they're like so sheepish to try to bring these claims because they're not trying to rock the boats because they've been like so, what's the word where you like start to empathize with your captor? What's that term? We're like Stockholm. They literally have Stockholm syndrome in their own community residence with their husbands because they've put up with the abuse for so long. And then Lively's like making these claims about Justin under these circumstances. It rubs me the wrong way in a much different way.
Yep.
Just professionally, I don't know. It just
you see these real victims all the time. So yeah, my very first post about this, because I was watching it before I took it to my YouTube, but I made a post on my Instagram after, because I was one of the ones who believed her claims at first, because I'm like, why would somebody lie about that? Especially someone so well known, she stands to lose so much. Like, and it's just my inclination as a woman. Like, why would a woman lie about such a thing? You know, it's such a horrible, life-changing thing to endure. Like, why would you make that up? And then when I started to see the other side, and the day that I remember, the day I was like, she's lying, I was shook. I was like, I felt physically sick. Yeah. And what I posted on my Instagram, and it's still up there, is that she single-handedly destroying the Me Too movement. Like, because I felt like all the progress that it took decades of women who had really gone through something horrible to be, sat up in a courtroom and have the opposing counsel criticize, well, why were you there? Well, why were you wearing what you were wearing? I mean, all of the women who had to go through all of that to get to where we were, and then this woman coming in with this nonsense has just taken us back decades.
Have we ever talked about like how it used to be like in the 40s and 50s, like where you could not legally make a claim against your husband for sexual assault because, well, you're married. If he wants to have sex, then you're just going to have to let him. I don't know what to tell you. Right. You could not legally bring a claim that your husband raped you, no matter what the factual circumstances were, because that's just how they thought in the 40s and 50s. It wasn't until like the 60s and 70s where they started to change that, and not even all the states, because every state had their own laws. And so there's literally states right now where there are courtrooms that will look at you sideways if you bring that kind of a claim.
Yeah.
And so think about the damage that Amber Heard did to, you know, the Me Too movement, and now Blake Lively, like the cherry on top.
Between the two of them.
It's look, and you know what? I've represented both sides. I've represented men and women. I've represented men falsely accused, and I've represented women that were in these really bad, legitimately bad situations. The last state changed that law in, I think, 1998. Changed the law in 1998, but good luck finding states that will consistently apply that law, because there's still states that are consistent about, come on, man, your husband raped you, give me a break, you know. And you could bring all the facts and then be like, there's literally there was a case literally like in 2025, in November of 2025, it's a Supreme Court case. I don't remember the specifics, but it was a case where a woman said that she was sexually assaulted by her husband because she told her husband no for sex, but she said that he had touched her private areas in, like, I guess, requesting, and when she said no, and then, but they were in like divorce proceedings, and so like she brought that up, and it became like this thing where she tried to get him for sexual assault, and then going like the Supreme Court, and they were making, I don't know what the final outcome was. But she was trying to bring her husband up on sexual assault charges for touching her privates while they're in the same bed. And she said no to sex. And he's like, all right, fine. And then rolled over and went to sleep. But they were also in a custody dispute. And so in that custody dispute, she's trying to get in the upper hand, saying, I was raped. And that was like her version of being raped. And so it's not just these Blake Lively cases and these Amber Heard cases. There are cases like that. There are a dime a dozen. They happen all the time. And I litigate these cases. But I also see the other side of it, where like there's ladies that are genuinely being assaulted by their husbands or their boyfriends or whatever, and they don't understand they don't know that they're in these abusive situations until I talk to them about like what the 6200 series in California stands for as domestic violence. Like you don't have to get beat up to be sexually abused or domestically violenced. It's literally anything that disturbs your peace. That could be financial abuse, it could be mental abuse, it could be psychological abuse, it could be trapping you in the home, it could be denying you resources unless you do certain things. You don't have to like show up to the police office with black eyes, but then you get like these bogus claims. And so like I feel like the legal sector altogether, judges, attorneys, are constantly on the defense. Like when my client comes to me with the claim of domestic violence, I'm immediately on the defensive. Is this a legitimate claim or not? And I try to hear them all out. I want to get all the facts, and it has to make sense to me, you know. And then I investigate the claims. But it just is. Yeah, there's not a situation where there's never a situation where I just 100% believe my clients ever, man or woman, because both men and women lie, and they will lie to gain the upper hand in court. And most of the time when there's children involved. Luckily in this case, there is no children involved. It's literally just Lively trying to make it out to be that she's this victim and champion for women. They literally gave her an award for like what was that award that she got?
Times 100 most influential people.
Because she's like this champion of women's rights. Get the fuck out of here. Justin Baldoni for decades before was doing this work trying to promote female rights, women's rights, and how men should treat women and all this kind of stuff. Basically trying to undo and unravel all of the good work that he's done from that spectrum of the gender wars or whatnot. It's just, this case has rubbed me the wrong way for that reason.
Many of us.
It's I think that I wonder often, like, why does this case hit so hard with the general public? What is it? It has to be that. It has to be that.
Yeah.
Like piggybacking off of Amber Heard, but like, what do we do with this? Like, are we just gonna like make these false claims? And like, at what point is she like actually damaging legitimate victims of domestic violence or sexual assaults because of her bogus claims? It's a legitimate question, and she's doing legitimate harm.
She is. So, and just like, so up till now, up till things like that, the rest of us were blissfully unaware. Now you tell us, because of what you've seen, that you no longer take those kind of accusations at face value. That's what's happened to you from seeing false claims. Now
Yeah.
the whole world is seeing false claims on a huge stage. I mean, just in the news constantly, because these trials last forever. And so now that's what's happening to the rest of the world. The same thing that's happened to you from being exposed to false claims now is happening to the world, and that's what makes me so mad. And like Gloria's comments here, and I'm sorry to hear about your experience, Gloria. She was talking about what she's been through, and that's why it made her so mad. I mean, it's shocking the amount of women that have had something awful happen to them. It's I think the majority, not the minority, and I think that's why we care so much, those of us who've actually been through it. And then to see her come with these little ridiculous things is it's insulting,
It's
you know,
hard because
and just knowing that it's going to make some women not be believed. Thank you so much, Aquanetta.
yeah, I never want to get to the point where like I disbelieve my clients. You know, it's so hard because I always have to keep myself objective with these things. Like when my clients bring me these accusations, these allegations, I always have to take them. I try to believe them, but I try to also take them like from the other perspective, because if my clients get caught lying about sexual harassment, or even worse, I've had parents accuse the other parent of child. I literally just had I literally just had a case of mine where this lady's boyfriend sexually molested the eldest daughter, and the dad was trying to file for full custody because he wanted an order that kept the molester away from his youngest daughter, right? And so in retaliation for that, the mom, that was the boyfriend of the guy that molested the daughter, brought a false claim of sexual molestation against dad, claiming that dad applied Carmex lip balm to the child's privates, and try to use that as evidence of sexual impropriety on the part of my clients. And when we started digging into it, like the skin, like, first of all, it was like it's like an old wives. It's like a cultural remedy where like some cultures apply Carmex to everything. You got a pimple, they put Carmex on it. You got a cold sore, they put Carmex on it. You got like a rash, they put Carmex on it. And so like this, my client's wife had applied this with like cameras rolling there, like there was security footage and everything. There was no sexual impropriety, and the doctors didn't even flag. It's just like, hey, maybe not like put Carmex on like certain areas. And we came to find out that the kid had a skin condition 5 months prior to this, where they were prescribed a medication that wasn't even being applied. And so I see these like false claims all the time, and it's always, I mean, in my profession, and because I practice mostly family law, these parents that are trying to gain the upper hand, they're making false allegations of child abuse, child molestation, sexual assault, domestic violence. And it's like 60% of the allegations, literally. 40% of the time I have a legitimate thing, but 60% of the time it's like some stupid thing that could be written off as like a big nothing burger. And it's really frustrating when I get these claims. And now we got these, I know I'm ranting. I got to cut this short. But I just get really frustrated by these Blake Lively style claims where they're trying to hold a guy like Justin Baldoni, when I know full well that her motivation the entire time was to steal the film from him, the rights from it, so she can make like a series, or like I don't know, like
she was going to do her own Deadpool.
It was going to be her Deadpool, right? Yeah. She was going to make like a part 1, part 2, part 3, her $1 billion franchise, stealing the rights from Justin Baldoni. She had been plotting this for years. It's disgusting to me. And so I understand from that perspective why people are so riled up by this case. And I'll stop my rant right there.
Yeah, but that's exactly it. So back to this one. So I'm going to go through this next one kind of fast, because this one is reasonable accommodation. This it doesn't have anything to do with Blake's case, but this is the reason why she was able to win the retaliation. So Yeah, this is the last of the 3 that did not get dismissed. And like I said, it's not a guarantee that she's going to actually win. It just means it survived the motion to dismiss. So, plaintiff has successfully alleged failure to provide reasonable accommodations under the ADA. And then there's these other things because it's a disability. This is not something that's available to Blake. She does not have this little special provision for any of her claims. So, and this is where it says this is what they did wrong. So it wasn't just that they had an atmosphere where there was alcohol. It was she was supposed to have been accommodated. They traveled apparently to Thailand, but they had agreed and were supposed to help her to attend AA meetings. And they did not. They did not arrange it. They did not provide transportation to it. They did not do what they were required to do under the ADA, which was to accommodate what she needed for her disability.
And that's
This
what
is
ADA
why,
stuff is. Like that's a big deal for ADA. You make ADA accommodations. And so, yeah.
and so this is not anything that's available to Blake. So now the rest of these retaliation claims, since these were not ADA, these were just regular state law and federal law, all of those failed. And let's see, what did I want to say about this one? I know it's already been almost an hour. How long do you have to spend with us, Omar?
Oh, well, I mean, I guess I'm in it for the long haul, but like, let's say
Okay.
30 minutes.
30 more minutes?
Yeah.
Oh, okay. All right. I just wanted to make sure because a lot of this stuff I want you here for, and some of it I can just do by myself. Like there's a transcript of a deposition of the Sony rep.
I'll tell you what,
So
I'm going to stop ranting. I'm going to let you get through this and I'll just be here to answer questions. How about that? I feel like
Oh,
I'll make this go longer than it needs to be.
okay. No, we like your insight. You're the expert here. So so this situation you had mentioned earlier, Omar, about Andy's letter. So
Yeah.
I think you had. So he writes his attorneys write this letter, send the letter to her attorneys, and what it's about is that she has said she's going to um she mentioned something about his cocaine use with cast members and what he does. So
Yeah.
this letter goes out. This letter not only goes to the attorneys, but it actually gets leaked to the press. And it lists, I didn't grab that screenshot, but it went out to several larger news agencies. And so it makes it out there. And even with that, still it's not considered an adverse action, or it still doesn't survive because there's not an adverse action about that, and there's no causal
No
connection.
causal connection. Yeah. And so like, look, there could be a letter about her experiences on the set and she could be reporting on things that she saw. How is that connected to the ADA stuff? How is that connected to any other claim? That should be like I said, Judge Liman needs to see the string. He needs to see the connection. He needs to see it connected to some thing that is alleged. Otherwise, he's not going to entertain it. And with Lively, with the 1 paragraph dismissal of her request for sanctions,
Basically saying I'm not even considering law.
yeah, it should let you know how important that is to him.
Yeah. And then this is the reason I got these next couple is because this is on the retaliation. But I feel like this is starting to take us into 47.1, which at the beginning, when they first released 47.1, some people reacted like it was some kind of humongous bomb that
I
was
remember those days.
Yeah, and I was kind of fighting it by myself and getting really badly criticized for my take on it. And but well, let me just say. So this says courts held that an employer who's facing a lawsuit filed by its employee charging discrimination can file a counterclaim without committing an adverse action. But the next page is the one that really got to me about 47.1. This isn't about 47.1 itself because this is not California, but I feel like this is where we can start to see maybe how it's going to go when he does finally have to rule about 47.1. So the Supreme Court has recognized that the right of access to the courts, due process, it's constitutional right. We all have
Yeah.
one aspect of the right to petition the government for a redress of grievances secured by the First Amendment to the Constitution. The
Yeah.
First Amendment affords the employer as well as the employee the right to petition the government for redress of grievances, and in particular, to have access to the courts for the redress of those grievances. 47.1 says you cannot file a discrimination suit
Yeah.
because someone has filed a lawsuit against you for harassment. They are taking away your constitutional right.
So you're preaching to the choir here, because I've been saying that 47.1 is unconstitutional for that very reason. Matter of fact, the law is that so long as there is some merit to the claim, if there's a modicum of truth to the claim, that it's not frivolous, that we're not going to penalize people for having, at least something that could be deliberated by jurors.
Mm-hmm.
That's the constitutional standard. That's your constitutional right to do that. So when you penalize somebody for bringing what seems to be a meritorious claim under 47.1, you should not be penalized by triple the damages, because you lose the claim because the jury didn't agree with you. That's not what that is your constitutionally protected right. And I agree with you that 47.1 is unconstitutional under that ground. Now, we don't get to that in this case because the claim was dismissed. And so under 12b6, no less, which means that it means that Justin Baldoni's counterclaim, if that stands and it's not reversed on appeal, it means that it doesn't reach the constitutional question, which sucks. I would have really wished that it survived 12b6, because if it's 12b6, basically, if it gets to the jury, there's obviously factual dispute there. Mm-hmm. If it's 12b6, if it's dismissed on 12b6, meaning it wasn't pled properly, and they had an opportunity to amend the complaint they didn't, because it was dismissed. Like, some of the claims are dismissed with prejudice, right? But if it's dismissed on 12b6 grounds, how could you say that there's merit to it if it didn't even survive a 12b6 motion? And so it doesn't really apply to Baldoni. But do I agree with you that 47.1 is unconstitutional insofar that if there's a counterclaim that goes to jury that gets denied, that should constitute treble damages to the prevailing party? No, I don't agree with that. I believe that's unconstitutional for the reasons that you're citing in this document here.
And this document, by the way, is still the one that Judge Liman himself wrote. These are his words here.
Yeah.
So, let's see where. The underlying principle is that the employer should not be required to forfeit a potentially... Oh, wait, I already read that, didn't I? Nothing in Title VII or any other anti-discrimination statute should prevent an employer from bringing a legitimate claim against a current or former employee simply because that employee has complained about what the employee believes to be discriminatory behavior. And I feel like him saying this means he still has to rule, because she's still trying to get 47.1 damages. Yeah. So I think based on this, I don't think he's going to find in her favor. I also think that a federal judge in New York does not want to make a ruling on a California state law.
Oh, I agree with that. I think that he could have easily ruled early on, because their argument was that a 12b6 dismissal constitutes treble damages, and we don't need to prevail on our SH claims to be awarded those damages. So if he wanted to, he could rule on it and set a precedent that, that's the case. But he has reserved that, and I don't think he's going to rule on it until and only if this goes to trial and has a result.
Yeah.
That's my I mean, if I'm a judge, if I'm Judge Liman, I'm not touching 47.1 on those grounds. Get the hell out of here with that. I'm not going to be the guy that sets precedent on those facts.
No.
For so many different reasons. Yeah.
Yeah. It's crazy. Indeed, the ability to lawfully prosecute even unsuccessful suits adds legitimacy to the court system as a designated alternative to force. Due process requires that there be an opportunity to present every available defense. These things I highlighted in blue, these are all US Supreme Court cases, by the way.
Mhm.
Further, employers should not be discouraged from expressing their own potential claims, at least whereas here such claims are addressed to the employee. Let me move these.
Employer
To
attorney.
the employee's attorney. Yeah.
Employees. Oh, I was wrong. It was a good thing you moved the comments.
Yeah, but yeah. So I don't know. I think this is I really like that this comes from Judge Liman himself. I think it says a lot about, and I will die on this hill, that 47.1 is absolutely unconstitutional.
To that regard, look, I know that there were attorneys that used to cover this case that were really big, that 47.1 was a big deal, and they believed it was constitutional. I disagreed with them. I still disagree with them. And the way that Judge Lyman has refused to rule on it, I'm inclined to believe that I don't believe that he thinks that it's necessarily constitutional either. And I think that Judge Lyman is smarter than you think. You know, he's not ruling on this case in a vacuum. I think he's very aware that 47.1 is a new law that came out in California, was hastily written, was irresponsibly legislated and put in practice, that there's no precedent on it. And for him to rule that a 12b6 dismissal on a counterclaim entitles the other side of treble damages, I don't think, I'm 100% certain that he is clear on the policy of why 47.1 exists. It was intended to prevent against the big bad employer with infinite resources preying upon and countersuing to death the little employee that has no resources, like for example the Tyler Perry case. 47.1 is way more way more applicable in that case because Tyler Perry's a billionaire, and the guy that's suing him for sexual assault is like this pissant actor that has not a name in Hollywood and is probably never going to work again in Hollywood, giving Tyler Perry's connections. And so 47.1 makes a lot more sense in that case. The problem is, in this case, Blake Lively is a way bigger thing than Justin Baldoni.
Right. It has more money.
And so to set the precedent with 47.1 in a case like this, where 47.1 was never contemplated for this specific situation, doesn't make a lot of sense. And so Judge Lyman, the fact that he's not ruled on their motion when he could have at any time, speaks volumes, because the likelihood is he's not going to rule on it until there's until and only if there is a trial. And I think that Lyman is savvy enough to understand that the likelihood of this case actually going to verdict, trial, and then a verdict is really small. And so if this settles, he never has to rule on it at all. How about that?
Really?
Yeah. If they settle the case, then 47.1 is dead. I'd imagine that a settlement would include dismissal of 47.1.
Interesting.
So that's the long game that I think that Judge Lyman is playing.
Yeah. You know what? I just thought of another case that I heard about it, and then I haven't seen anything followed up. I don't know if they ended up quietly settling really quickly. There was a Smokey Robinson case too. Did you?
Oh, I have not heard about that case. What's going on?
I was a little devastated because my parents used to listen to him, and I loved his voice.
Yo, I went to a Smokey Robinson concert.
You did?
Yes, I saw him.
I didn't even know he was still alive. I didn't know like when he sang. I just know I liked it. Was it cool? I bet it was cool because it
was weird. It was weird. He still sounds the same. I'll tell you what, he still sounded the same. I mean, this was like over a decade ago when I saw Smokey. He sounds the same, but he was definitely like doing certain things with like the dancers on stage. That was weird because he's like a 70-year-old man. and like those dancers were like in their 20s, and it just was like the optics were weird. But it's Smokey Robinson, you know.
Yeah, I mean, nobody had a voice like it. His kind of stood out.
Nobody
But
still has a voice like. Let me tell you something about Smokey Robinson. His falsetto voice, that style, many have tried to imitate it. The stylistics, they had very famously a singer, their lead singer tried to do that falsetto in the style of Smokey Robinson, but it never had like the touch of honey in Smokey Robinson's voice, the way that he had in all of his songs. I mean, Tears of a Clown, all got. He has. I mean, he was around like in the late 50s. He was like one of the pioneers of the 1960s Motown with Berry Gordy, Marvin Gaye, all of those like those groups where they would go like barnstorming all of these venues and play like these vignettes. He would write all of the songs. He was the poet of like the 20th century Motown, 60s and 70s, writing all of these songs. He was singing and producing and writing, and he made a shit ton of money doing all that stuff. He's a legend in Motown. It really sucks to see him go down for molesting the maid or whatever he did.
Yeah,
it was. What do you think about that case?
It was multiple different maids.
Oh, that sucks.
Yeah, and it came out in the course of this case, and so yeah, that's what that's what made me think of it. I'm like, why not this case? Why are these 47.1 people? Why are they not jumping on that? Because I would think if I had labored so hard to get a bill passed, which is so hard to do, and then got it passed, and then the likes of Blake Lively wanted to be the one to use it first, I would be
that
like,
would
no,
piss me off, man.
You can't use my law.
They
right?
did not write 47.1 for Blake freaking Lively. Get out of here.
That's what I would be saying if it was something I had worked hard to do and somebody was making a mockery of it like that. Like the last thing I would do is be writing an amicus brief to make it be used. I'd be like writing one to say, don't let her use my law. It's not for her.
Man.
So yeah, but yeah, that's what it was meant for. Is like you mentioned Tyler Perry. I'm not familiar with that lawsuit, but I thought of like that one.
Well, you should familiarize yourself because Tyler Perry, it's parallel to this case insofar it involves sexual harassment on a movie set. But Tyler Perry was the guy. Like he's bankrolling the entire thing. He's literally a billionaire. And this actor, he was a guy, a male actor. He had some bit parts here and there in some of the Tyler Perry movies, and he was like constantly being inundated by like these weird sexual text messages from Tyler Perry. And then he sues him for sexual harassment, and then Tyler Perry countersues. That's exactly the kind of situation that 47.1 was written for. Like the countersuit plaintiff that is a billionaire to this guy like making $50,000 a year, if that, like a bartending in LA somewhere. And like he's got these side gigs in LA. He's trying to catch a break. And like Tyler Perry, he's basically Harvey Weinsteining this guy.
Wow.
In a very different way. And so the parallels are there. The Tyler Perry lawsuit is the lawsuit that Blake Lively is trying to file as Blake Lively against Justin Baldoni. And the optics don't match and the facts are not there.
Are they using 47.1 for that?
I don't know. I haven't covered that case in a long time. You know what? I should start covering it again. Who's talking about The Last Dragon? The Last Dragon is one of the greatest cinematic experiences ever. The Last Dragon, 1985. Man, what do you know about The Last Dragon, Cassidy?
Nothing.
Nothing. Bruce Leroy and Show Enough. Come on, man. Oh man. Now I have the power, and they're doing the kung fu. It's like one of these spoofs, like they remade they try to make a Bruce Lee film, but with like black folks. And so they had Bruce Leroy, and they had Show Enough was like the guy, and they had this average. It's like, who's the meanest? Who's the baddest? Who's the biggest mofo in this town? Show Enough. And it's like, man, watch that movie with your husband. I'm telling you, late night. You got to watch The Last Dragon. It is a cult classic. It's like 40 years old now. I'm just saying.
I'll add that to the list that you've given me so far. I forgot the name of the other one you told me.
I'm pretty sure Berry Gordy produced that film. Berry Gordy was making movies.
Town guy, right?
Yeah, the Motown guy, and I'm pretty sure I think he produced The Wiz with Michael Jackson, Diana Ross, and he produced The Last Dragon. I'm pretty sure. I might be wrong. Vanity was in that movie. Oh man, they had rest in peace to Vanity. But she was in that movie. They were trying to debut El DeBarge, like it was like part music video for like this 85 up and coming El DeBarge. It is so 80s. Just watch it. Okay. When you have a good glass of wine and you're sufficiently faded enough.
All right, let me write this down. The Last Dragon.
What was the other one I told you to watch?
Yes, either. That's a person or a movie?
The Last Dragon is a movie. The actor. Yeah, the main guy in that film is Bruce Leroy. He's played by Timac. He's like 62 years old now. The guy that's like the main villain, I forget his name. He's like in his 80s now, but it's just you know what? Just watch it. I should say no more.
Okay. All right. I've written it down now.
Okay.
Okay. So back to this.
My wife watched this movie, by the way.
What's that?
I've made my wife watch this movie, and she was like, "Why are we watching this?"
That will be me. That will be me.
Because I once watched it when I was 5, and it was awesome.
It takes a really exceptional movie to get my full interest. Otherwise, I'm like on my phone or reading a legal document or something. I'm not the best TV. You don't want to watch movies with me.
You just gotta stick with it, man. You just gotta be patient and be faded, and you'll love it.
Okay. So back to this. Now we're getting to the gender discrimination, and we have the Title VII. And Ricardo's telling me to watch it. We have Title VII, and we have the New York state claims for this. And I feel like I looked up things like the time standards, the statute of limitations, stuff like that, and there were some similarities there, but beyond that, I'm not sure. So I wanted to ask your expertise when we get to what these New York laws say, and then maybe you could give us a clue about how California compares to the New York laws. Sure. But in the legal standards for Title VII, there is a 3-step burden, and there's no way around it. There's no way around it. So those who've been watching my summary judgment episodes, they can probably recite them by heart. But let's see. Is this the state one? What is this? Because this is 4 steps. So I don't know how we got from 3 to 4 here. It said 3, and then it jumps to these, and there are actually 4. So the standards are, she has to belong to a protected class. So she's a woman. She was qualified for the position she held. She suffered an adverse employment action, and the adverse employment action occurred under circumstances giving rise to an inference of discriminatory intent. Now, okay, I'm sorry, I got ahead of myself. This is the part that we've been talking about that I said my people can probably recite by heart. The standard has to be more disruptive than just a mere inconvenience. It has to alter the work environment. It has to be, and then the action, the changes have to be something like termination of employment, a demotion, decrease in wage or salary, a less distinguished title, a material loss of benefits, significantly diminished material responsibilities, or other indices unique to a particular situation. What was my point about that? I'm sorry, guys. We got so distracted onto some of these other things.
No, you're fine. But to answer your question, there's number one, BHA, you get more damages, obviously, as famously cited by Lively's attorneys. There's no cap on compensatory or punitive damages, but Title VII caps damages, I think, at like at $300,000 or whatever. And Title VII, I think that it requires at least 15 employees In California, I forget what the number is, but it's less than that. It's easier to get FEHA in. California standards, as you might imagine, from the federal Title VII standards, it's just easier to bring a FEHA claim. They're based on like the same principles. But the reason why you would bring FEHA the way that Blake Lively has is honestly, it's for no other reason than there's no cap on damages. In Title VII claim, you're capped at $300,000. Title VII, it could be millions. And so, I mean, that's the most practical. I mean, there's other subtle differences, like just in terms of requirements, but the biggest one is just the cap on damages for Title VII claims versus FEHA. That's really it.
Oh, okay. Thanks. So, Aquinetta has to go. So thank you so much, Aquinetta.
What are you working on a Friday night for? What the hell? I don't know what the hell go.
Okay. Now this
well, happy
part,
Friday to you, Aquinetta.
this part I have questions. I've always had questions, but I really have questions now after reading this. So with the Title VII, we're still talking about that. Filing a complaint with the EEOC or an equivalent state agency, it has to be done within 300 days of the allegedly discriminatory action. Only incidents that took place within the timely filing period are actionable. And then he does the math. Oh, wait, not on this page. The 300-day look-back period is triggered by the filing of an administrative complaint addressing the specific type of discrimination at issue. With respect to plaintiff sex gender-based claims, therefore, the relevant date is June 30th, 2023. Now, this is for the Cohen case, when plaintiff amended her charge to add claims of sexual harassment and discrimination. So he does the math here. And then I did the math on Blake's then. So I've never understood why Wayfair didn't include this statute of limitations in Blake's claim.
Maybe they just missed it. But in Title VII, I think the statute is what, 3 years?
I think it's Title VII is the 300 days, and
Title
California.
300 days of FEHA. I think FEHA claims are 3 years.
So does that make? That would only work for FEHA, or does it cause the Title VII to extend to 3 years as well? So that's my question.
That's a great question. I don't think. Well, I do not believe that Title VII and FEHA are held as concurrent causes of action, meaning that they're their own separate things. So Title VII with a 300-day statute of limitations, it should be an affirmative defense that you plead that it's not within the statute of limitations, therefore should be dismissed. I don't believe that the Wayfair parties have done that, and you're right to call it out. That seems strange. They could have. I know that the CRD complaints, there's a 3-year look back, not a 300-day look back. Unless they're tying, and I'd have to look at the complaint again, unless they're tying the Title VII claims specifically to events that happened 300 days prior to the complaints, which would have been all 2024 stuff. And maybe the title or the FEHA stuff is the stuff that relates back to like 2023. That's the only logical explanation that I have.
I get it. See, because her date, so she filed the CRD complaint on December 20th, 2024. So 300 days prior, her magical cutoff date is February 24th. Well, January 4th was the 5-hour screaming session, and nothing happened after that. So
January 24th, would that have been?
January 4th, I think, was the screaming. Was what? January
Even
4th?
That's more than 300 days before the.
Yeah. So February 24th is the cutoff, and she claims that after that whole 17-point thing, the whole second half of everything, that nothing happened there. She has said that. It's on the record. So so
it might be a moot point. It may be a moot point because
that's what I was wondering.
Are we certain that Baldoni and the Wayfair parties did not list as an affirmative defense statute of limitations as the Title VII?
I'll have to go back through their affirmative defenses. I did a video on that, but that was like almost a year ago.
I know.
I
I don't.
talked
I
about
don't remember.
unclean hands
Yeah,
and yeah, there was something I talked about back then, but they do have affirmative defenses, so maybe it's in there,
I
and that's why
feel
they
like
didn't bother to mention it on the MSJ.
when I discussed the 12B6 stuff, or maybe it was the MSJ stuff, that I had mentioned something about statute of limitations in Title VII. I just I can't remember off the top of my head. It was a while ago. Maybe, but you're right to question it. If they haven't raised that issue already, there's got to be a reason for it. There has to be.
Mm-hmm. Yeah, because
They're
that's
not going to miss the statute of limitations argument.
right. Yeah. So
I wish I
it's
could give a better answer than that.
yeah, I think you're right. I
don't
think
have
it's probably in the equitable or affirmative. So I just a side point, when I find a new word like this, or not a new word, but a word that might be new to you guys, when you see both statutes ordinarily toll, I put it in pink, toll the limitations period during the pendency. So that is, well, I've got my little written definition, but if you want to add something to that, Omar.
about tolling the statutes. It just means that they are going to go by it usually when you're tolling the statutes, it has to do with discovery of the offense. So if like something like a breach of contract happened in 2022, but the first you heard about it was in 2025, well, then the statute tolls to the discovery of the offense. And so the statute of limitations begins to run in 2025 as opposed to when it actually happened in 2022. So if there's tolling statutes, I'm assuming it would be on a discovery of the offense kind of thing. Maybe that would be the smear campaign stuff, because they didn't learn about the smear campaign until that summer. Maybe that's what it is. I know I'm talking out of my ass. It's just because I don't remember how they dealt with that in their response to Title VII stuff.
Yeah. So yeah, so basically there's a time clock running on the statutes of limitations on things. And so you can stop the clock, which is called tolling, temporarily suspend it, right?
Yeah.
Yeah. So that it doesn't expire. Like it's like a stopwatch, right?
Yeah, they give you a fair opportunity. Like the statute of limitations gives you a specific amount of time to act upon something when you learned about it, not when it happened, when you learned about it.
Yeah. So it's an adjustment of that statute of limitation stuff. So oh, this was just the point about where there were allegations about things that happened to other female cast members. And he says right there in the middle, plaintiff does not allege that any of these comments were made to her or in her presence, or even that she was aware of the comments before her contract was not renewed. They thus cannot stand alone as the basis for plaintiff's claims. So I feel like this is really important when it comes to Blake trying to bring in, because that's one of the things that she claims, because Wayfarer's team has said so many times, well, nothing, even Blake admitted that nothing happened in that second period after the strike when they filmed for the second phase. And they say, oh, that's not true because Isabella said blah, blah, blah. Well,
nobody gives a shit about what Isabella said. She's not the one bringing the lawsuit.
Exactly. So this is what Liman himself ruled on a situation about allegations against other female cast members. He's like, doesn't matter. You weren't there. So,
was that a Brooklyn accent? What the hell was that?
it was my attempt at it, but it was really bad. So. I'm kind of regretting doing it. So,
somebody said it sounded Southern when I said, what the hell?
We're trying them all out today.
I know.
So, and then when it comes to Jenny Slate, like I said earlier, she's like, it was taken care of. So yeah, I don't think that those are going to help her in the way that she thinks that they will.
Yeah.
So this is kind of a long one. Let me see what my notes are so we don't have to read it all. So a lot of Blake's claims, they came later much. Some of them popped up in her deposition,
Yeah.
which was months and months after she filed a complaint. They weren't even in the complaint, but all of a sudden she's tying Steve Sarowitz in, and his is the weakest. It's like I literally, it was another one that literally made me laugh. So they're like, do you feel sexually or sexually harassed by Steve Sarowitz? And she's like, well, I feel like he didn't listen to my complaints because I'm a woman. And they're like,
Yeah.
well, did you ever complain to him? No, but
I remember that. I remember that whole thing.
it's so stupid. But
Yeah.
she's still trying to keep Steve in there, and it's crazy. Like, that's how they're trying to, because they said he needs to be dismissed from this, and she's like, no, because he blah blah blah. So
He didn't
that
respect my opinions as a woman. They were like bending over backwards to like accommodate her demands the entire time. Get out of
yeah,
here.
which she never brought to him. So, but yeah,
Yeah.
that was something that didn't arise in anything until her deposition. So, and then some of the other claims too, they kind of came up in her deposition, which was way late. So, wait, what was my point of this? It was something about that.
Well, I can't help you with your points, but
Yeah.
I could read the words that are on the page.
All right. So in this case, they said that her protected activity failed because she didn't that it was a bald allegation, that it was threadbare, and it was not specific enough to say that there was protected activity, that there was a complaint made. So my question, yeah, that's right. My question to you on this one was the fact that she gave more specific things, such as Jamie in the makeup trailer, those allegations,
Yeah.
or because, yeah, does that stop hers from being dismissed as a
No,
threadbare or a bald allegation, or is that
it's
still
not.
fine because it's not a
Yeah.
formal complaint?
Because it still has to be reasonable. Like that's kind of the catch-all, right? It still has to be a reasonable complaint under the circumstances.
Okay.
And so just because, she's making those claims and those are in the complaint, they have to meet all the other elements of sexual harassment. And so I don't think necessarily, I mean, there's temporal claims when it comes to smear complaint, but I think that the sexual harassment claims, that the questions that Liman was asking to them really went towards the heart of, is this a reasonable complaint that you're making? And it was this argument about, didn't you invite Jamie into the trailer as you were breastfeeding? Why did you do that? If it was like this private thing, why would you stand there like naked in front of him and say that, no, it's okay to have this conversation as I'm standing in front of you? How dare your eyes like divert downwards? Like, what are you doing? Did you try to cop a look? No, I'm standing. You said it was okay. I said that I could come back later. You told me to come in. And so that
Right.
whole sequence, yeah, does it look, if you're going to bring a sexual harassment claim, if it's going to survive MSJ, every single element has to come into play, that there's a modicum of truth or something for the jury to deliberate. Now, if it gets dismissed for some like temporal claim or causal connection claim, I don't know, but I feel like in the MSJ arguments, there was also the part where Lyman was not buying the reasonableness of Lively's complaints. And so if it doesn't get kicked out for the reason that we're talking about, it's going to get kicked out for the reasonable aspect of it all.
Okay, good. Well, part of it, what really makes that one sus is because you have Jamie's deposition about what happened, you have Blake's deposition about what happened, and then there's two hair and makeup women, and none of them match. The only thing that matches is that Jamie and Blake both say that she said, yes, come in, and that's when he entered.
Yeah.
But the other women have him entering and her trying to stop him. They don't have her inviting him in, but she even admits that she did, and Jamie says that she did. But the one of the women says she was standing there in nothing but what are those things that go up your butt? A thong, And the other one says she's sitting there breastfeeding. And one says she's got the baby on one side and she's covering the other side with a washcloth. And the other woman says she's throwing a cape around her. So what in the world? Like, I don't think a jury can sort through that and sort out what really happened, because you've got 4 different stories. But the only facts that match, or the only story of any that match up, are Blake's and Jamie's that say she invited him in, then he entered. So there's that.
Yeah.
But let me see what was. Oh yeah. So do you want to do this at the end? Go through the deposition? Because if you have to go, that's something I can do, but it's really, really interesting. It's Angie's deposition that talks about the HR complaint.
You know what? Let's do it. How long is it going to take?
Well, I highlighted parts so we can skip through some of them.
Yeah, I'm down. I mean, I'm already hour 40 in. I can go at least another 20 minutes.
Okay. So, I thought this was so good because it's all about was there an HR complaint? And if there wasn't, she says that in May that she complained and that she tried to make an HR complaint with Sony because this poor lost woman had no idea how to file a complaint. So crazy. So she talks to Ange from Sony in May, and they ask, and this is this first bit is Ezra doing the deposing. So she asked, do you recall what it was that you wanted to review and discuss with Miss Lively? And she says, I think it was wardrobe. But and then Ezra's like, oh, that's the wrong answer. You could feel Ezra through this whenever it's like not what she wants. So she's like, in light of today's news, that seems very, very small. So she's like, what were you talking about? What was today's news? And I think she's hoping to get to something big. And she goes, I believe it was that she had been exposed to COVID. I was worried that the baby might have COVID. And so Ezra's like trying to steer her back.
How did you learn that? I don't remember. Did you talk with Miss Lively? Tell her that yourself? Yeah, definitely talked about it. Well, did you talk about it before this call? I don't remember. And you said you think you probably did have a call with her on May 26th then? If I said I'm calling you in moments, I would have called her in moments. Sitting here today, do you have a recollection of that phone call? Exactly? No. Do you have a general recollection of it? I have a general recollection. And generally, what do you recall? I mostly remember her being very concerned about the COVID. And if I'm correct, I don't know if it was before or after. I'm not great with the timing, but I recall that she had been in the hospital and the baby had been in the hospital with RSV. And so that potentially the baby would have COVID. As a mother, that was concern, very concerning. Mm-hmm. And then she continues, the phone call. Do you recall whether it was just you and Miss Lively on that phone call? I think it was just the two of us on the phone call. Do you recall how long it lasted? No. Do you recall anything else about the phone call other than what you described? Specifically on this call, I can't. I know there were many things we were talking about at this time, but I couldn't say for sure exactly. And what were you on May 26th? Were you in LA? Yeah, I was in LA. And was it your understanding that Miss Lively was in New York, New Jersey? New York, I mean, as if it was night. I'm probably going too far. My bad.
Yeah, let me skip that. And if we could probably just hit the highlighted stuff if you want.
All right. So I'll tell you what. You play, I will play Ezra, and you play this lady.
Okay.
So have you now told me about all of the things that you recall Miss Lively complaining about to you about Mr. Baldoni?
That I can recall in this moment, yes.
Going back to Mr. Heath, you said there was an issue regarding the showing of the birth of his child.
Uh-huh.
Tell me what you recall about that.
I was on set. I wasn't there. I was not present when it happened, even though I was on set. I believe Jamie came to me first and said he showed the video. Justin asked him to show the video, and she was surprised and did not. I don't know how he said she didn't take it well.
Did Mr. Heath describe what had shown? Miss Lively,
Did he describe it? No.
did you at some point talk to Miss Lively directly about that?
Well, yeah, there was an interaction. It was very brief. I think we were at lunch and she walked by and said, she mentioned the video and being very unhappy about it. I forget her exact words. She said it to me and kept walking.
Did she tell you what she had seen in the video?
She may have. I don't remember the phrasing.
Did she tell you that Mr. Heath's wife was nude in the video?
She may have.
Did she tell you that when she first saw the video, she didn't know what she was looking at and thought it was pornography?
No, she did not say that.
Did she tell you that what she saw, Mr. Heath's wife's genitals in that video?
She did not say that.
But do you recall her maybe saying that? His wife was nude in the video.
She could have said that, yeah.
Did she ask you to do anything about it?
She did not.
Did you think you should do anything about it?
No, I saw the video.
What did you see?
I saw a woman in a tub giving birth.
What exactly did you see? What was it? Was she naked?
I knew she was naked. There was water. I don't remember seeing any genitalia.
Did you, when you say giving birth, did you see a baby crowning? That's a weird effing question to ask. Jesus.
Because that's what Blake claimed. Blake claimed she was spread eagle crowning, but it was a water birth. You don't.
Yeah.
You're underwater.
Physics does not dictate that you're going to see a baby crowning. Just the way the light reflects off the water.
Yeah. No, I don't remember that.
You remember a woman alone in the tub?
I think someone was behind her holding her.
Do you know whether, well, let me ask you this. How did you see the video?
Jamie showed it to me.
How do you know that the video you saw was the same video that Miss Lively saw?
I don't.
Did you think the video that Mr. Heath showed you with his nude wife in the tub was an appropriate thing to show in a workplace? Objection. No. And why not?
Well, it was my understanding they were talking about the birthing scene. It didn't come out of nowhere. They were talking about a birthing scene and so wanted to share it. The thing that I think is the inappropriate part is that before showing the video, no one stopped to say, we have a video of my wife giving birth in a tub. Would you like to see it? That should have been done before showing a video.
So you think they should have gotten consent from Miss Lively before showing her a video of Mr. Heath's naked wife in the tub? Objection.
That would have been a smart thing to do, yes.
And did you understand how Miss Lively might have been uncomfortable seeing that video, not anticipating and giving consent in advance?
Yes.
Other than learning about the video from Miss Lively and Mr. Heath, is there anything else that occurred from your end with respect to that video?
I don't think so, no.
Did you tell Mr. Heath not to do things like that?
I think I did.
Did you tell anyone in human resources at Wayfair that Mr. Heath had shown Miss Lively's video of his nude wife in a tub giving birth?
No.
And you didn't think that was important to do?
I thought it was a misunderstanding. I believe Jamie when he said Justin told him to show the video because they were discussing the birthing scene. And I believe when Jamie showed her the video, it had been prepped. And so I believe the intention. I believed it was a mistake.
I'm going to sexually harass you with my wife giving birth in the tub. Get out of here. That was his intention, totally. When did you see the video?
I can't remember. I think it might have been after. I can't tell you that I really know.
Now you mentioned that trailer incident.
Yeah.
What happened there?
I was told Jamie had to discuss something with Miss Lively. He knocked on the door. He told me he heard come in. He went in. And then I heard that Miss Lively did not say come in, so he was surprised he came in. Then I believe, and I could be wrong about this, but I believe she then was like, I don't know if she was getting body makeup removed or breastfeeding. I don't remember what was happening. But then I think she said he could stay. Anyway, it was definitely a miscommunication, and she made it very clear that she was uncomfortable. I felt this fell into the loose, it was a loose set, and she wanted to have a meeting about it, and we did at the end of the day in her trailer. And I think it skips some pages here.
Yeah. So do you recall whether Miss Lively, asked you to do anything about these various issues she was raising to you at the time, including May 26th?
Yes, she asked for help in getting rid of the first AD. Again, not harassment.
She didn't ask for anything else?
No,
Did she tell you that she wanted to file an HR complaint?
she did not. Oh, she may have over COVID.
So you recall her telling you that she wanted to file an HR complaint with Sony?
I recall that actually in person, not on the phone.
So there was a time in person she told you she wanted to file an HR complaint with Sony.
She didn't use the words HR, I guess she means here. I don't remember her using the words HR. She was very upset about the COVID and did not think the COVID protocols were being followed. And she wanted to have Sony get into it. And I said, we don't run the movie. The way protocols are done are with, and then it skips pages again. So the only HR complaint that this woman knew about was about COVID.
And it was like she's speculating that maybe it would have been that. And is that even an HR complaint about a COVID thing? But it has nothing to do with the sexual harassment. You're right.
Yeah.
You're absolutely right.
So it does not appear there was ever a formal HR complaint about harassment.
She says herself it's a miscommunication. There may or may not have been consent. She's not clear about whether or not Lively gave consent. There's some matter of fact, the way that she describes it, it seems to me that she did give consent, even if, or for no other reason than she thought it was like a loose set and that there's just kind of a thing to do. I'm just going to go on a limb and say she probably was standing there butt naked with Jamie Heath in the trailer, regardless of whether or not she's getting body makeup removed or breastfeeding. Even when you're breastfeeding, you're not sitting there just like with your stuff all out, unless there's like a kid attached to it, especially like if there's a pump. Like you just like wear one of those things, those towels, or there's like those covers, and you can like hear the machine going off, and like there's stuff going on under there. Nobody looks under there. It's just like it's a thing that happens. Like women with pumps, like they pump. Like I remember my wife used to have a pump. She had like one of these state of the art ones. She got one from the hospital, and she had like this like really nice fancy one. And she always had like a cover. Like there was never a time where she was like sitting there standing fully nude. It just doesn't make sense. Like the version of events that Lively gives is kind of all over the place. Even this lady is giving her version of events. It's kind of all over the place. At best, this was a miscommunication. What it was not was an incident of sexual harassment.
Yeah. And so there's a lot more that's really interesting to this, but do you want to go back to the rest of it for sake of time, or do you want to keep going through?
Oh, it's up to you. You're running the show tonight.
Yeah,
I am your guest tonight.
Okay. All right. So do you want to keep reading then?
Let's do it.
All right. Because you see like what the complaints were. They're just so ridiculous. Okay. So yeah. So this is back to the first AD, I think, is assistant director.
All right. Did you help replace the first AD?
Yes, I did.
Do you know whether anyone else thought there was a problem with the first AD?
I think Alex Sachs thought there was a problem with the first AD.
Did anyone else speak with you about concerns they had with Mr. Baldoni or Mr. Heath?
Well, define concern, because there's a lot of complaining on a set. There's a lot of personalities. Yeah, I think probably Alex Sachs.
Did Jenny Slate?
Yeah, Jenny Slate. Yeah, the sexy comment.
Oh my God. Did Jenny Slate's manager?
Well, I'll tell you about the conversation with Jenny Slate's manager. Jenny Slate's manager called me and in a very general way asked me, like, what's going on the set? She didn't get into anything specific. She just said, what's going on? And she intimated Jenny and Blake had concern. She didn't know really what it was. And I just said to the manager, have Jenny call me. She can call me directly.
Is that what Miss Lively told you?
I don't recall.
But you don't have any reason to dispute Miss Lively's account?
No.
And you mentioned that Alex Sachs had concerns. What were those?
Alex Sachs's main concern, is that she felt sidelined. She was used to running her own shows, producing her own shows. She was brought on this, and she felt like it was not her set to run, was the main one, as far as I know. Oh, wait, I got that wrong.
Do you want to correct something?
Yeah, I thought Justin had said she looked sexy, and it says here, you were standing there for the thing, and he said to me, he said, I look hot.
Who is that you were reading from?
Jenny. So far we have Alex being mad she doesn't have the control that she wants, so they fired this AD. Yeah. And it's the same one that Blake brags about firing in her PGA letter. And then we have Jenny. We keep hearing that he said sexy, but Jenny's own text says hot, not sexy.
Yeah, hot as in it's really hot in the onesie when it's like 90 degrees in here without AC.
Yeah. No, this was the comment to Jenny.
Oh.
Yeah.
I stand corrected once again.
No, it's okay. So, yeah, I just skipped that last page. It didn't have a whole lot. So I remember her having unease on the set, talking about how Blake had a lot of concerns. She shared them with Jenny. Jenny had the experience of the hot comment, and it just felt tense. You know, things felt tense on the set. She was very all over the place and wishy-washy about it a little bit. And the part I really specifically remember is asking her at the end, are you asking me to do something? And she said, no. My manager said I should call you.
And you didn't feel after hearing that both Miss Slate and Miss Lively were uncomfortable that there was something you should do, whether asked or not?
To date, Jenny Slate told me the director told her she looked hot in costume. No, I did not think anything from that needed to go to HR. And the majority of Blake's concern, the majority of them were the running of the set, his inexperience, the first AD, the COVID. And there were the incident of the video and the trailer. But no, I did not think there was, I thought it was a poop show, but I did not think it was.
Oh, Cassidy's too innocent for this world. Also, Alex Sachs felt sidelined as well. Generally, right?
And then Friedman.
Objection. Could you let her finish her answer? Listen, Dick. Oh, I'm sorry. I forgot. Cassidy's in the chat. Can I use curse words?
Oh, and then you're back to Ezra again.
I'm sorry. Was there more that you were trying to say?
I thought it was a poop show, and there were those accidents alone were not reason to call HR for a movie that we were co-financing and distributing.
How many women on us? I feel so bad for like cursing now.
What? No, go ahead. I just don't do it. I don't think anyone else does. Go ahead.
How many women on a set have to be uncomfortable before you think it rises to the level of calling HR? Objection.
They didn't like him.
What do you mean by that?
They didn't like him.
So you discontinued their views on him?
I've heard of 3 incidents. You can ask me this 100 times. I'm going to tell you the 3 incidents I know over and over again.
I think that's still you.
That's still me. Oh, the different colors blew me, or blew my mind. The video, I saw the video. The trailer, we had a meeting in the trailer. It was resolved. And the director called Jenny Slate hot in front of 300 people on set. Those were the 3 incidents. No, I did not think there was reason to call HR.
Okay. Yeah. Let's take a look at exhibit.
Sorry, I'm going to skip
this. It's just not going the way they hoped.
Yeah, she's trying so hard. Now here, this is, I believe this is Friedman, the one deposing.
All right.
So now you're.
I'll start with Exhibit 24 is a true and correct copy of the text exchange you sent to Jamie Heath, Justin Baldoni, Alex Sachs, and Ashley Marks on March 31st, 2023. Who is Ashley Marks?
She's the head of casting for Sony.
The Text message states from you. This process is poor. We spend time discussing and making a decision, and then you just do what Blake wants with no regard for your partner. Do you see that?
I do.
And what was meant by this message?
I don't know what it was regarding specifically, but this sounds like I'm really not happy. It sounds like we made a decision and then the decision got reversed, and it sounds like I did not get consulted on that.
Very. Did we
Yes.
skip a page?
It skipped some pages, yeah.
Okay. Did you think it was inappropriate for Mr. Rothman to say that Blake Lively wasn't as alluring as she needed to be for the movie?
That's hilarious. I'm sorry. I just imagine Blake when she read that.
What do you mean I'm not alluring, you dick?
I
How
think
dare you.
Mr. Rothman thought this was a private communication between him, me, and Sanford, and I do not think it's inappropriate.
Did it make you uncomfortable?
Not at all.
Did you think this was harassment?
No.
We already discussed that phase 1 of the principal photography began on May 15th, 2023, correct?
Yeah. Then they start talking about locations and stuff. So I'm going to skip if that's okay. And then
did you talk with anyone at Wayfair about why they agreed to the 17-point list?
No, I knew why.
Why?
Because there was a tremendous amount of money that had been invested and spent, and we had to finish the movie or it was unreleasable.
Did Blake Lively threaten to leave the movie if the 17-point list wasn't signed without alteration or revision?
That's my understanding.
Do you recall telling Jamie Heath that you thought Blake was an effing terrorist?
Yes. All right, let me skip. Let me see if there's anything more important that we still need to. Then they talk about Blake was rewriting and this was the process from the beginning. Okay. Oh yeah, this part is important. So start with yeah.
Did you understand that a formal HR process had not yet occurred as stated in the letter with the 17-point list?
I didn't know about any HR. I never heard about any HR complaints.
So was that a yes?
That's a yes.
Had Blake Lively made an HR complaint to Sony?
Not that I know of.
Do you have any reason to believe that Blake Lively had filed an HR complaint with Wayfair?
No. Okay. All right, let me see. I think that might be all the important stuff.
Yeah.
Yeah. So, yeah, I think we can go back now. So that was the whole bit, because this was about whether or not there was a formal HR complaint. So I think because Blake had tried to say that she complained to Sony, and so that was a formal complaint. But then you hear the person that Blake spoke to say no formal HR complaint existed.
Yeah.
So
big effing deal. I mean, if we're just tying it back to that case that we were talking about earlier, and tying it back to the MSJ arguments, no formal HR complaint means no causal connection. No formal HR complaint means that Wayfair was not compelled to do anything. No formal HR complaint means that the veracity of her claims are severely compromised. And what it necessarily means is that Judge Liman is going to be inclined, as he has ruled in the past on this very specific issue, that there is not a causal connection between Lively's claims and what anything that was done in retaliation thereto. Therefore, sexual harassment claims are going to be out. Well, obviously, Judge Liman denied Lively's sanctions claims, which was the easier of it, in a paragraph when he could have been much more verbose. And 8-9 months ago, nobody's prejudiced. We're done with this. We're finished.
Now, this at the top are the New York State standards. How does that compare with the California?
So this says to establish a claim of retaliation under 215, the plaintiff must allege participation in protected activity known to the defendant, an employment action disadvantaging the plaintiff, and a causal connection between the protected activity and the adverse employment action. I believe California has, I'm pretty sure that's like the exact same, more or less the exact same standards, just different wording. I don't got the California language right in front of me, but it's not substantially different. Matter of fact, it's substantially the same.
Yeah. That's what I was thinking.
Yeah. And then it goes on to say plaintiff must plead while employed by the defendant, she made a complaint about the employer's violation of the law, and as a result was terminated or otherwise penalized, discriminated against, or subjected to an adverse employment action. And California is no different. You have to, if you want the employer to do anything or you want to get them in trouble for something, you have to have left a paper trail by a formal complaint, either through HR or otherwise, that puts the employer on notice of malfeasance on their part that must be corrected. That's usually like 90% of the battle when it comes to these kinds of claims. And so New York or California, really not much difference.
Yeah. And don't they get a time period to try to correct before an action can be brought?
Yeah, but it's not initiated until there's actually a complaint filed. Like that's why I've been saying the formal complaint is so important because it makes the other party do something. I believe the time period is like 90 days or something like that. I might be wrong on that. It's either 90 days or 180 days. I believe it's 90 days where they have to address immediately. And depending on the severity, like if it's like severe sexual harassment, their response, if it's like, if they literally take 90 days to address something that's like severely happening, it's going to subject them to liability. It's like a case by case, but it puts them on a definitive time period by which they must respond or do something, lest they face a FEHA claim or a Title VII claim or whatever, or otherwise. And so that's the significance of not filing an HR complaint. If you don't file the HR complaint and you try to then bring a Title VII claim or a FEHA claim, how are you going to do that? How is the employee supposed to know, the employer supposed to know anything was wrong if you didn't submit a formal complaint? She's going to say, well, I brought the 17-point list. Well, that's just a spitballing. From the employer's perspective, it's like we're having a circle, we're having a campfire session, we're having we're having a closed door team meeting. We're going to air out our grievances. There's nothing where there's any safety concerns here. We have an employee that has something that she wants to address with the other employees. It doesn't rise to the level of a formal HR complaint where HR has to act on anything. That's the way that they're going to play it. And that's the way that they did play it. Lively makes this 17-point list of demands, and then Wayfair complies. Even if that's the thing where she's going to say, "Where you see, I did make a complaint." Okay, well, you were accommodated. So now what? Yeah. What are we doing? Like you should, if you don't bring a formal HR complaint, it's not documented, and the company is not required or compelled to do anything. If it's literally just for bringing this up in the conference room at 4:45 on a Friday afternoon because you got something to say, because you got grievances to air, that's not going to rise to the level of a FEHA claim or a Title VII claim, but for very specific facts that do not exist here.
And how about this last?
Blake Lively's in a lot of trouble with this with this case.
Yeah, this last sentence, is this the same in California law too? Because this brings in the retaliation.
Courts have required the employee to complain about conduct that is a violation of the labor law in order to pursue a claim of retaliation. It's substantially the same. It's substantially the same because, as you can see, she's bringing a FEHA claim, but she hasn't filed a formal complaint. That might be the fatal. The final. Well, what am I trying to say? Her fatal flaw in her complaint is the fact there was never a formal complaint that did not, like I've been saying, the Wayfair parties were not compelled to do anything because there was not a formal complaint, and that may very well be the fatal flaw that MSJ's the claim itself.
You know what we haven't heard about for a long time?
What's that?
Do you remember that they hired a neutral law firm to do the
Yes,
investigation, and this team went nuts trying to stop it, and they were never able to stop it? We've not gotten to see any of the results of that investigation.
you're right. I'm sincerely doubting that we're ever going to see the results of that investigation.
Yeah.
I think that if it was going to be meritorious to Lively's claims, we would have already seen it. And the fact that we haven't seen it leads me to believe that it was unimpressive.
Mm. Yeah. I wonder if it's something Wayfair is gonna bring.
They, I'm sure, have asked for it in discovery or tried to compel it in discovery. Matter of fact, wasn't there discovery motions going back and forth about
Yeah.
those investigation results? Do we know what what
There were
happened with that?
huge fights about it, and they were insisting that Wayfair had to have something from it. And
Yeah,
Wayfair is like, the investigation is not over. We don't have anything. And there was like this huge fight. It was like last summer, I think. And then it got dropped. And so I'm assuming at some point it completed and they gave it to Blake, but Blake never used it in any
right.
way. So that means it's Wayfair has it to use, but they
It
didn't
doesn't
use
necessarily
it.
mean that it's
Right.
that there's nothing there. They might be using it perhaps for impeachment purposes. Sometimes that happens.
Yeah.
Like, in other
So
words, there's things in there where they made specific findings where they're going to ask questions, and if the witness says the wrong answer, then they're going to try to impeach them with the results of that investigation. Maybe, but I'm speculating. I have no idea. My instinct tells me that if there's anything of note in there, we would have already heard about it in these MSJ arguments specifically.
yeah, that's what I was thinking. So this, I feel like there was something in this top paragraph that I didn't understand. This is
As previously noted, plaintiff complaint is replete with allegations. Some support her claims, while others do not. And at this point, defendants have offered no strong reason for the court to line edit the complaint and determine which allegations are immaterial or impertinent. By the way, what are we reading?
that's this is the end of his order. So that's the sentence. Court defendants have offered no strong reason for the court to line edit the complaint and determine which allegations are immaterial or impertinent and which are not.
Oh, I gotcha.
Yeah, that
Yeah, basically, this is directly from the denial of sanctions, correct?
mhm. No, this is the denial. This is back to the Cohen case.
Oh,
This is him, the granted in part, denied in part, motion to dismiss, where those
okay.
3 claims survived and the rest of them are gone.
I gotcha. And so they're saying plaintiff's complaint is replete with allegations. Some support her claims and others do not. And at this point, defendants have offered no strong reason for the court to line edit the complaint and determine which allegations are immaterial or impertinent and which are not. Having determined that some of plaintiff's disability-related claims survive defendant's motion to dismiss, the court will not now prejudge the materiality or relevance of those paragraphs to plaintiff's surviving claims on the sterile field of the pleadings alone. In other words, the statements that are inherent in those complaints having survived, I'm not going to go by and like redline, in other words, take out specific language. You haven't given me a reason to do that. Therefore, the paragraphs are going to stand as is for the surviving allegations.
Oh, thank you.
Yeah, he's just abstaining from whittling down the complaints any further for the surviving complaints, obviously.
Ah, okay. All right. And that's it.
Is that an AI image of me? Is that an anime of me?
It's no, it's so I'm doing this kids YouTube stuff. I think I told you before, like learning to read thing. So it takes a picture of you and cartoons it.
That's cool.
So, yeah, that's the the one of me is for that series. And then I just did one of you too. I took one of your one of the ones you had on your YouTube channel.
That doesn't look like me at all. But I'm going to show my girl. Hey, you want to see what that looks like as a cartoon?
What's that?
I'm going to tell my kids, my girls, that I'm going to show them this picture. I'm going to say, hey, you want to see what your dad looks like as the cartoon?
Yeah, it came up with that. So,
that's really cool.
Oh, sorry.
Oh, is that our signal? Is that the sign that it's time to wrap up?
I think so. So Judge Liman said that Wayfair didn't have to give over the results of the third-party HR investigation. Okay, I didn't remember how that ended.
I didn't remember either.
So,
I don't remember.
yeah.
No.
Yeah, I remember the last I read about that Gottlieb was just like, "I know you have something." And they're like, "We don't." But yeah, it was kind of one of those crazy like fights that never ends. So the motions impending, I think, are gonna be like that. If the discovery fights were any indication, I think this is gonna be just as explosive. Do you think?
Yeah. Yeah. Well, like a lot of the stuff that they haven't turned over yet or have signed over on, I mean, they're still in play for impeachment purposes. And so everything is still in play. Like you may very well see some of that stuff come in if we do a trial. I just really, and it's going to suck. It's going to be so anticlimactic. Imagine covering this case for as long as we have, and there's not going to be a trial. It's going to be like the most anticlimactic result.
Yeah. Yeah.
Possible. But my instinct tells me that once the MSJ ruling comes out, this is going to be dead. They will quickly resolve it.
Yeah. Because if it leaves her with nothing to like really get money, like I've started to wonder. I've started to wonder if part of this situation, because when the discovery, the Great Unsealing came out, it turned out her beverage line was in serious trouble. Like the year before, they wanted to shut it down. The hair care thing was not doing well. He has invested in so many different places that I don't believe he has much cash. Their house they've been building for like 7 years, and it's just the foundation. Yeah. So I wonder, like, I'm starting to feel like this was all a big thing to try to sue and get money. I don't know. I wouldn't put anything past these people at this point.
That backfired. Again, I'd estimate $1 million a month in attorney fees.
Yeah.
For Lively. So we're probably $12 million in. 12 to $18 million, I'd guess. Maybe 25.
Definitely over 10.
What a waste of money, man.
Yep.
I gotta start getting some higher profile clients. I need some $1 million clients. You know what? If you want to file a lawsuit in Hollywood, I am your guy. You just
Yeah.
Oh, I'm kidding. Sort of. Anyway, it's Friday night. And I think it's time to go to bed.
Yep. Definitely.
I know, definitely for you. I mean, gosh, it's like almost 3 a.m. for you. Jesus.
I keep yawning now. Once it started, it won't stop. So, but yeah, this is I just hope this is a start of a lot of no's coming her way.
Well, I've been saying the whole time, like they kept getting all those wins towards the middle of litigation, and when it was happening, it's like, who gives a shit, man? Like when it comes down to like the merits of this case, when they actually start litigating that stuff, she's not going to do well, and that's kind of exactly what's been happening. I remember people being so up in arms about like her like minor discovery wins or not getting the extension that they wanted, or whatever. It was like it was fool's gold for her, because when it comes down to the merits of the case, that was the weakest part of her case, and here we are. Every one of these substantive decisions I anticipate are going to go really poorly for her, and so that's what we got to look forward to.
Yeah. The only bad thing is that she won so much in the press, so that people who didn't ever deep dive into the filings or watch these kinds of things on YouTube and TikTok, they only heard all of that noise. And so they still think he's a creep and he did all these things. And so she won a lot of PR stuff, unfortunately, that I think it's kind of hard to ever change those people's minds, because they've heard that and thought that for so long that those people will remain thinking what they think, and that part bothers me.
There's I watched a really good psychology video about why cult members hold on in the face of so many facts to the contrary to their beliefs that are so clearly deficient. And their support of Lively largely becomes like a part of their identity, to the point where they don't care how weak the evidence is. They have identified with defending her, and they're going to do that no matter what kind of evidence comes out. And that's just how it is in so many aspects of 2026, many different areas. I'm just saying that the people that are supporting her now, they're not going to change their mind. It doesn't matter what happens in trial.
Yeah, that's true. That's true. I think there were some new people, because I see more of like the population, the general population's opinions of things, like on X. That's where you see, and I did see a lot of new people come around and say after they saw that stuff released, they changed their viewpoint. So it is possible that some of the people who aren't just like dead set Blake Lively fans, those ones are still, it's crazy. Those ones on X, they just drive me crazy, because no matter what comes out that she did, they will excuse it. And see, that's the difference. Like, I am not in this because I'm a Justin Baldoni fan. I didn't even know who he was when this started. It's about like who's right and who's wrong to me, so that if anything ever came up that one of them had done that was like really heinous, I would be absolutely fine to call them out on it.
Yeah.
I've not seen anything like that yet, but that's the difference. Like, I'm not a fan of somebody, and that's why I'm doing this. I just feel like this is the truth. So, but
You're a
yeah,
justice seeker, and therefore you think critically when others do not. That's really the difference. It's a lack of critical thinking that happens to be a deficit in people that follow this case. And I mean, pop culture in general, the deficit in critical thinking with the advancements in AI and all of this information overload we have, it's critical thinking is in the decline. And so I don't know, man. It's not going to get any better, I guess.
no.
I hate to end on that note, but that's kind of where we're at.
Yeah, that's where we're at. I'm just glad that my formative years were not now. I feel sorry for young people of this generation.
Man, if I grew up as a teenager nowadays, I would cheat my ass off. I wouldn't write for shit. I wouldn't write anything for, man. I'll chat GPT everything and like just whatever. No, they make it way too easy for this kids. And then I don't know, man. I'm really thankful that I had the opportunity to find my own writing voice prior to ChatGPT forcing their slop down my throat.
Yep.
That sounded weird. I'm just saying. You know what I mean?
Oh, I know exactly what you mean. Well, thank you so very much for joining tonight and for all of the insight provided.
Well, thanks for having me. We you know what? We really should finish the
Murdock
thing.
Yes.
One of the day we'll plan it. I'm going to be traveling next week. We'll see what happens. We'll just have to see.
Have a wonderful, wonderful time in Mexico.
Thank you. Be
safe. Be careful.
I will do my best.
And enjoy.
Yeah, we're just going to try to stay on the resort. No telling what's going on over there. They're killing cartel leaders, and people are angry. So we're going over with an abundance of caution.
Yeah, I hope most of that's died down now.
Hopefully, we'll see. But all right, Cassidy, I think we're going to call it a night. Thanks for having me. For everybody else, love you guys. Have a wonderful weekend.
All right. Have a great night. Thank you, guys.
All right. Bye-bye.
Bye.